Okay, hello everybody, and welcome back. This is week 4 of the ADCRR Healthcare Class Action Trial Roundup expert panel. I don't know, we could have some more labels on this. We are again joined by a very esteemed panel here. We have Jimmy Jenkins from the Arizona Republic, who's been covering this story both with the Arizona Republic and previously with KJZZ. And Jimmy's been on this story and the prison story writ large for a number of years, for about 5 or 6 years now. We have Julie Gunnigle, attorney here in Phoenix, Arizona, and former law professor, and Billy Peard, a civil rights attorney that works on prison litigation cases out of Tucson. We do not have Stacy Scheff with us this evening. She had to beg out at the last minute because of an engagement that came up. So we will be moving forward with our panel, this esteemed panel this evening. And I want to start with Jimmy. Jimmy, can you give us what happened this week in the final week of the trial?
Sure thing. So there were just 2 days of the trial this week, Tuesday and Wednesday. And they started with a continued cross-examination of Dr. Joseph Penn. And this was the gentleman who is running healthcare for a bunch of facilities in Texas, essentially. And there was more. I believe this was his redirect. He went through direct examination, cross-examination, and we talked about that last time we all met. This time there was just a few follow-up questions. Of note, Judge Silver asked him again about these mortality reviews that certain people have access to, which I would love to have access to. If anybody out there knows how I can get my hands on those babies, we should talk. But so he went through these files, which are they're kind of like the end-all be-all determination. And why I would love to get them is because it's like what the prison does after someone dies. They do a review. It's like a really great process, actually. And they say, what went wrong here? And what could we have done better to prevent this death? So it's really like a great thing that they're doing. And he reviewed those. And when the plaintiff's attorneys reviewed them, they found all kinds of really damning stuff in them. Things like, you can check a box that unfortunately, it's cold. It says like, could this person's death, should it have been preventable? That's like a yes or no on this question. And many times they check, yes, it was preventable. And then they say, it's because we didn't get them emergency services quick enough, or it's because they'll look back and they'll say, well, it looks like we missed a cancer diagnosis here and let it go on for like 2 years. So, it's really damning stuff. So plaintiffs experts go through these, they flag all kinds of things. We heard about them throughout the trial. This man who's serving as a defense expert, he went through the same documents, and he only gave Judge Silver one example where he felt like, I believe he called it like there was a breakdown or something, and even then he kind of said like, well, this was a difficult patient. It was someone who was like, had severe illness, but they were refusing services. And, it seemed like there was probably reason for that, like they had mental illness as well. But anyway, so, out of all these cases, the main expert for the defense, the only time that they come forward and say, what, we had an honest read here, and we decided that there was just one death out of all the hundreds of deaths, thousands of deaths that they probably could have processed. So I thought that was interesting. And Judge Silver asked him about it as well. And she was basically asking that question. She was like, so you're telling me you went through, and she listed a few herself that I think that she found troubling. She's like, you went through all this, but you felt it was only necessary to bring up this one death. And he was like, yes, I did. And she was like, okay. And then they moved on. But I made note of that, thinking like, I don't think she was impressed by that answer, or she was surprised by that answer. So there was more of Dr. Penn. And he said there was also a kind of a back and forth about the way he took notes. He had toured a bunch of prison facilities, and he's writing down notes. He then goes back and says he gave those to a transcription service, which were then provided to the law firm, which is representing the state. And then that's what the law firm turned over to the plaintiffs on discovery. The plaintiffs suspected that there was another version. It turns out there was. There was a big back and forth about, like, what happened here. Eventually, the final version was released. It had been edited, but it was unclear who it had been edited by. So just kind of, again, that, they were trying to impeach his character. They were trying to show that, well, this person may have been not an honest reviewer, or he may have been hiding some things. And he denied that. But again, it was another plaintiff attempt to impeach his character. And I think it was maybe successful because Judge Silver, again, like, asked several questions about, why did we get different results here? What is the problem? So that was Dr. Penn. He said, the healthcare is not perfect. We could provide more care and services, but in totality, I found that the system is providing reasonable access to care and continuity of care and constitutional care. So that was the kind of the big takeaway for I would say, what is probably the star medical witness for the defense. And then I wanted to tell you about, we also heard from Dr. Owen Murray, which I believe was on Wednesday. He was another medical expert, also from Texas. He runs the University of Texas Medical Branch Correctional Managed Care Program. He's a vice president. They have 3,500 employees at 80 facilities, and he's in charge of nearly 100,000 prisoners in Texas. So again, he came in and he echoed many of the same things that Dr. Penn said. He said, I found things to be adequate levels of care, compared certain things to Texas, just kind of gave an overall blanket approval of the things that he saw. And he also, I think they used him as a way to try to take credit away from earlier witnesses that the plaintiffs put forward. So, for example, he would say, well, I looked at what Dr. Haney said, and I didn't agree with the way he reviewed the data. And he explained why. One big thing the defendants have been arguing all along is essentially that the plaintiffs, the people representing the prisoners, they've been like cherry picking. They didn't do a true random sampling. They're saying, well, you went and you found the worst of the worst, so of course it's going to be awful. That's kind of been how the defense is coming back on this. And that's what their experts said as well. They're like, they didn't do a really good job of random sampling at all. They brought you all these horrifying cases. And so there's been back and forth about that. But that's kind of what Dr. Owen Murray served to tell. And then the last thing I wanted to bring up is something that I'm still reporting on and we'll hopefully have out soon. But we heard from the vice president of Centurion, which was fascinating because you don't normally hear from the people that run this private healthcare company at like an administrative level. We've heard testimony over the years from nurses and doctors, but this is a person really calling the shots. One of the most interesting things that came out in his cross-examination was he had sent an email with a document in it before this trial talking about essentially if he was given a wish list or no funding cap, how would he fund the medical operations in the 10 state-run prisons that they have a contract for? And he answered back, and they showed this document, and there's more than 150 positions that he would have added. And these were like at the admin level, nurses, doctors, pretty much across the board. He even talked about how if they could, or if they had the money for it, they would implement what's called a man down team, which I think would be a very good idea. I don't know, John, maybe you can talk about this, but people are always telling me, medical people that work in the prisons are always telling me, I can't do my regular work. I can't pass out pills and go around and make sure everybody's doing okay, doing my job, because I'm constantly running across the yard, responding to a serious incident. Someone's having a heart attack, someone's having a seizure, so here you have the guy running everything saying, well, it would be nice if we had a team who could just respond to emergencies like that at every prison. Again, like a really good idea. But the whole premise of this is ridiculous because they're saying, oh, well, if we had unlimited funding, well, Centurion bids to the state with, they come up with the number that they think that they need to appropriately take care of healthcare in Arizona prisons, as do all the other companies. And then, whoever has the most experience and usually the lowest price is who the state goes with. So it's been the plaintiff's suggestion, and it's been what I've taken away from my reporting, is that these companies, they come in with a very low estimate, and it's basically probably like, what is the minimum we think we can get by with, you know? And so it's a terrible way to go about doling out healthcare, but because the profit incentive is there, this is where we are. So you have companies coming in saying like, okay, you know, what is the lean number that we can keep these prisons functioning? And that's what they pitch. And here you have someone saying, well, you know, what we'd actually like to have to give good care is this. And it turned out to be 150 more positions. So I just found that to be a stunning admission. And the defense attorneys were trying to not have this allowed into evidence. So clearly, you know, they saw it as a damning thing as well. So that was the big standouts, what I saw from the testimony. Next steps are Judge Silvers said they're now due to turn in the findings of fact and conclusions of law. Lawyers, is that the correct phrasing on that? I believe it's okay. And so the way Judge Silver, who's been really great, by the way, just kind of explaining things, talking about why she sustained something, why she overrules something. You know, I feel like she's been running the courtroom really impressively, and for me to watch, it's been kind of, you know, easy to like follow along and digest. She says now both sides will have a few weeks, actually into January, before they submit what they think their best cases were. They're supposed to link to things, cite things, and basically it's like, okay, here's our wrap up. Here's why we think that our argument is the best, and then they have another like 2 to 3 weeks, maybe 4 weeks to respond to those. And then those are due in the middle of February. So I talked to some of the attorneys and they seem to think that, you know, March would be the earliest probably when we would get a ruling. So there you go, John.
All right. Thank you, Jimmy. That, again, incredible. One quick aside, and it's a little bit of a digression from our normal conversation here, but I just happened to look the other day at the procurement site, the Arizona State procurement site, and I was looking specifically at this current contract. And I looked at it a few months ago, and it was at $16.47 per day per inmate in the Department of Corrections. When I looked at it the other day, that number had gone up to a little over $17. There's been an increase. It's like $17.20. Jimmy, are you aware? Was that something that was happening? Do you know why that happened and when it happened specifically?
No, I don't, John. That was
Okay.
not in our production notes. So,
All right. Well, yeah. So I just found it interesting that.
but so what you're saying here is that the projected cost per prisoner per day has increased on the bid, like on the posted bid, or on the posted
on the contract
request?
on the procurement site, yeah, the current per diem is.
You're talking about the current. Oh, well, that would have been agreed to when they agreed to this new 200 million plus contract. So that should, okay. So then that should have happened July 1 of this year. That should have changed. Okay. So that because they did increase. I thought you were talking about the new request. So if that happened on July 1 when the state said we want you to hang on for, I think it was like 13 or 14 more months. And we're going to pay you extra for what you had to do for the pandemic, and we're going to pay you extra to recruit more people. So the final for the current fiscal year that we're in, plus 2 months, is something like $216 million, and that's how they would have broken it down per prisoner per day.
Right, and I happened to have the great privilege of speaking to Julie last night, and when we talked about that for a moment, and we sat down and did some math. Julie, do you remember what the numbers were on that? Because we were talking about the cost of health care at that rate per person, per capita in the Department of Corrections that's being provided relative to insurance costs that we're paying out here in the private sector, and it being more. Julie, do you remember what the numbers were, or even close on that?
Yeah. It was in the realm of, what was it, $6,000 per incarcerated person per year as like the yearly premium. Mm-hmm. And in looking at that, I mean, that's far and away, you know, I think my insurance is expensive, and that's more than what I pay. And I have access to doctors whenever I want to see them, and have, you know, actually pretty stellar healthcare. So it's such a big disconnect between what we're paying and what we hear people are receiving.
Yeah,
that seems right, because I heard someone at the trial throw out about like a $6,600 a year number at one point. So that seems accurate.
Yeah, that I think that's pretty close to the number that we came up with yesterday when we were looking at that, and it's remarkable to me that during this class action, and I understand what you're saying now, that a lot of it was to address, or at least on the front end was to address some of these issues, but we're paying even more and more money, and when you sit down and look at it, the whole reason that we were moving into privatized, or what the taxpayers of Arizona were told back in 2009, 10, 11, was that the reason we were moving into privatized healthcare with the Department of Corrections was because it was supposed to save the taxpayer money. But when you look at those numbers, it's costing more than private insurance out here in the open free market, and that has got to shock the conscience of the Arizona taxpayer, because we were sold a bill of goods, and not only are we paying more. And we were, misled on that. But additionally, look at what's happened in the meantime. We are expending all of this money in this class action suit. Heretofore, the money that we've expended in it, this trial, and then what's going to happen moving forward once the judge makes the decision, and all the additional expenses that will be related to whatever remediation process that the court puts in place, if the court does find that the state has not met its burden to provide adequate health care, mental health care, and the issues relative to solitary confinement. So this thing just keeps getting more and more expensive for all of us, and it's manifest in all of these issues, and it's something that we need to be aware of, and it's a holistic issue to me, and we need to look at this seriously as citizens of the state. Jimmy, thank you so much for that recitation of events. That was incredible, as always. I guess what I want to do is, as we're in wrap up, I'd like to kind of shoot it around the table here and just ask everybody, do we think that the plaintiffs have met their burden? And we can talk a little bit about that. Maybe Billy or Julie, if you want to take that, either one of you, about to recite again what the burden was that the plaintiffs had here in this class action lawsuit. And do we think that we've met that burden, the plaintiffs have met that burden, or do we think that the defense has prevailed here, or potentially prevailed?
Well, I would start out by in answering that question by observing that 7 years ago, I think 7, Jimmy, years ago ish, when this lawsuit started, I would posit that the state of Arizona thought at that time that plaintiffs had met their burden, and that's why they agreed to enter into a settlement at that point in time. And for the last 7 years, essentially, we've been operating under that regime up until 6 months ago. So I think the state probably understands that the plaintiffs have at least come close to raising their burden. From what I understand over the weeks from Jimmy's great reporting, that the evidence has not changed a lot over 7 years. In other words, it hasn't gotten better. There's been details upon which things have improved. And I think it's a little bit like a game of whack-a-mole. Some things have improved while other things have slid backwards, and vice versa, depending on the month, depending on the year. But overall, it seems to me that yes, they have met their burden on certain things. Keep in mind that this lawsuit involves healthcare writ large in the prison system among the 30,000 plus prisoners. And then there's a specific emphasis, or what we call a subclass, with regard to the mental health care provided to a subset of those 30,000 individuals. From what little I'm seeing and reading, it seems like they've made their case most forcefully with regard to the mental health care. I hope and I think that they've probably made their case on all of it in certain respects, but I think if I were to place a bet, the mental health care aspect of the lawsuit, they've probably made the most forceful impact on the judge, from what it seems to me.
Jimmy, from your purview as as an objective observer out here, how do you feel? I mean, you've been there. You've been the one that's been watching this day in, day out machinations of this trial. What's your takeaway on that?
I think it's good to repeat what Billy said there about, if the state agreed to it in the first place 7 years ago, then they must have thought they were in trouble back then. And yeah, I would say just watching things over the years, certain, like he said, certain things have gotten better, but many things have gotten worse. So knowing all that, Judge Silver knowing that, reviewing the past several years of Judge Duncan's orders and everything, um, it does seem like things have gotten worse in many ways. And so I think that, yeah, I think that it seems like they've made the case uh, with that regard to that. I remember at the beginning of the trial, it was more about physical maladies not being treated, cancers not being treated. But yes, it does seem like we have spent a huge majority of the time on the mental health care. So I would agree with that as well. That kind of seems like a real, a real solid case they've made there. Um, and the other thing that I found interesting is that it seems to me like the defense has spent most of the time playing defense instead of coming out and saying, here's a great example of someone who received excellent care, and look at them now, they're out in the free world and doing awesome. Like we didn't hear that one time. If I was setting this up, I think I would want to, feature more of those success stories maybe. But again, I think because they're faced with an onslaught of so many bad things happening, they went with the tactic of, okay, we have to impeach the character of people and their job, qualifications. We have to impeach those, and we have to get Judge Silver to think that like these people are saying that things are terrible when they're really not that bad. And hey, here's a few areas where we've improved. And it's a tough market out there, so it's hard to hire doctors and nurses. We've heard a lot of that kind of thing. But I haven't heard anyone other than Dr. Penn who did this emphatically, like at the very end of the trial. He came out and he was saying all these glowing things about like, it's a wonderful place to be. It's like a magazine or it's like a brochure. And then several of the medical experts have repeated what Director Shin said about, and they even wrote this in their declarations, that they said in this instance, I feel like these incarcerated patients had better access to care than in general society. So, I think they're still going with that argument, but it just didn't seem to be landing. And instead, and Judge Silver, I'm just trying to watch like when she got engaged, when she asked questions, it was mostly about plaintiffs' examples of really horrible things happening. And it was always kind of, she was, why didn't you do this? Why didn't you take this course of action? You really didn't think this was a problem, and she would ask those questions, and then she wouldn't press much harder, because I think that's probably not, she's going to reserve that for whatever she writes in her order. But it just seemed like watching her, that she was affected by all the bad examples and not really moved so much by what was put forth as good examples. So taking that against each other, it seems like, she was not impressed. And I would say that, she's probably going to rule in one way or another in favor of what the plaintiffs are arguing.
Right. Yeah, very good. And I think one of the pretty obvious defense strategies too, Julie, was that the defense attorneys were working to demonstrate to the court that these aren't systemic issues. These are just a number of isolated individual issues. And why is that important? Why did the defense go there? And what's the challenge there for the plaintiffs?
Yeah. Okay. So to like back up in big picture, because this is, I think, what we did the very first time. And to answer the question first, I think they crushed it. I think the plaintiffs absolutely nailed the burden of proof and that they're going to prevail. But I am fundamentally biased. But they made us a promise on day one. And what that promise was is that the treatment of incarcerated people and patients inside our system met the standard of deliberate indifference. Not just that it was bad, not that it was really bad, but that it was systemically bad, and that there was a level of mens rea that they knew about it and failed to act. So if that's the bigger picture, the way the plaintiffs teed up this case, I think, is absolutely beyond genius, right? Because they told us what their strategy was on day one. You're going to hear individualized stories, qualitative stories about how bad the care is. And that was through the bravery of so many incarcerated people who I fear for their safety and the retribution that they're going to receive as a result of testifying. And then the qualitative case, we're going to show you through our expert witnesses that it was chronically understaffed, that there are certain threshold levels that we can empirically meet. So a quantitative and a qualitative case together. And what I heard in some of the pushback from Judge Silver was how much that qualitative case and those individualized stories were landing with her. And that makes sense. The defense is proceeding the way they're proceeding because I'm not sure they can make the case that Jimmy wants them to, that it is in fact glowing, and they have to play whack-a-mole because that's, I think, the only credible defense. And even then, as we're hearing some of the pushback from Judge Silver, it just doesn't sound that credible. Which is the last thing that I wanted to latch onto, because I think Jimmy absolutely nailed it with respect to the other strategy, which is to go after the credibility of witnesses. Because this next step that happens is arguably the most important, right? You're going to, no matter what, spoiler alert, no matter what, there will be an appeal, right? It doesn't matter who prevails at this point in time. We're going to see action going up through the Ninth Circuit and possibly even the Supreme Court. The biggest thing that Judge Silver has to determine, and I think the most important thing, is the credibility of witnesses. Because when you look at a case on appeal, by and large, you don't get to challenge the facts that the judge has decided. Those are all viewed with extreme deference. And in most cases, the most extreme form of deference is in the credibility determinations of the witness. So depending on how she chooses to write up, who she believed was credible in light of all that impeachment evidence, I think that's going to be the most key and least overturnable issue on appeal.
Okay, very good. Yeah, and I want to circle back on appeal and appeal process, and I want to talk about that because you're right. There is an absolute inevitability, irrespective of what the decision is. There's going to be an appeal. There's two sides here. They both have appeal rights, and I want to circle back on that. But before we get there, Billy, let's talk about findings of facts and conclusions of law. What is that? Why did the judge give both sides the burden? What does that process do, and what is that telling the judge?
Right. So take a step back for those of you joining us for the first time tonight. This trial is different than a typical television trial. There's no jury, so the judge is both the judge and serving as both the judge and the jury in this particular trial, and that's what we lawyers refer to as a bench trial, so called because there's no jury. The bench, where the judge sits, is the only decider in the case, and so in a jury trial, you sort of bifurcate the decision making. The jury this is at least in theory how it's supposed to work. Doesn't always work in reality. But the theory of the law, the abstraction of the law, is that the jury in a jury trial is the sole decider of the facts. What happened? Did the car actually run a red light or not? That's a fact. And then the law, how the facts apply to the law, that's the judge's job. Most often in a jury trial. But here, where you have a bench trial and there's only a judge, the judge is deciding both matters. And so that's kind of to answer your question, John, what the difference is between findings of fact and conclusions of law. The judge has to make a finding of fact. That's kind of the judge putting on her jury hat, acting as a jury, essentially. That's the findings of fact. And so the judge, in a couple months' time, I expect, will publish a written recitation. It'll literally be numbered, like in paragraph form, paragraph 1, paragraph 2. This is what I find. This is what I find to be the truth, the big T truth. And then the conclusions of law is her taking off her jury hat and putting on her judge hat again. And in the same document, the same written document, in a few months from now, she will be saying, okay, this is what I found. These are the facts. This is the truth as I find it. And then below that, she's writing the conclusions of law. This is why it matters. This is why it matters that the car ran, that I find the truth is the car ran the red light, and this is how the law applies to that fact. Because the car ran the red light, I find that the law in Arizona is, somebody has to pay somebody or whatever. So that's kind of the difference between the conclusions of law and the findings of fact. Now, before the judge publishes that final order containing those two elements, she's inviting both sides, the attorneys for the state of Arizona and the attorneys for the challenger, the plaintiffs. She's inviting them to propose findings of fact, to basically say, Judge, we were in trial for 4 weeks together. This is our belief of what we proved. This is what we believe, that the big T truth is this, and you should find that this is the truth. Not what the other guy's saying.
I see. Okay, very good. Okay, so why is it going to take so long? Why are we going to wait so long for a decision? And I'll tee that up to everybody, whoever wants to grab that.
Well, I
Yeah.
can say just,
Okay. No, you go first, Jimmy.
I can just say just what happened in the courtroom. At first, Judge Silver said something to the effect of, okay, I need the first briefs, or I need these first reports by early January. And someone from the defense said, well, Your Honor, it's the holidays. We've all got stuff going on. Will be cool to have a little more time. And then Judge Silver said, I assume that's the case for everyone. And no one from the plaintiffs said anything. So she's like, okay, well, what do you need? I have another couple weeks. So the lawyers essentially said, like, her first pitch was not enough time, or because they're taking vacation, it's not going to be enough time. So they got pushed back a little bit for that. And then they have to respond. Then they have to like read those arguments themselves, consume them, and then respond to them. And they said that would take another couple weeks. So everything is due to the judge in the middle of February. And then you have to think it's going to take her several weeks at least to go through all that and make a decision. So, that's the way it played out. And they were just kind of like hashing this out. Like, what do you need? How much time? Is that good? Is that good with you? Like Billy said, because it's literally just like, a few attorneys and the judge just all kind of working together on this. It's been fascinating to see that kind of thing play out, but that's pretty much how they decided.
Julie, did you have something you wanted to add to that?
Well, yeah, I just wanted everybody to keep in mind too, like how large a team it is needed to put on a case like this, right? And on the plaintiff side, I mean, I know that we talked to a few of the attorneys, and what did they say, John? It was well over a dozen. Was it 24?
Yeah.
Attorneys have had their hands and eyes on this case,
Right.
And I just want to emphasize, 'cause I know some folks think like, oh, it's the law, it's going to move at the speed of slow, and I totally get that, and I'm empathetic to it. But I really cannot emphasize enough, like, what it is to go through a transcript that's going to be as voluminous as this one, and exhibits as large as these, and to take all of that and to distill it into something smaller. And by the way, what we get is not going to be like a 2-pager. This is going to be, if not dozens, hundreds of pages, just putting together what those initial findings of fact and conclusions of law look like. So it truly is an extraordinary amount of work during an incredibly busy time. So it's not attorneys dragging feet in this rare instance. It is literally that it is that level of work.
Right. And that's a question that I had raised before too, about this particular judge has got to go through all of that evidence, the testimony evidence and the documentary evidence. And I remember right at the beginning of the trial, Jimmy, I think that you had taken photos and had posted in your reporting the actual literal carts full of boxes of documentary evidence that were, and I remember going down to the trial myself, and it was sitting in front of the judge's bench, and it was as high as the bench of documents. Multiple, as a wall of boxes. And now not all of that stuff comes into evidence, and that's the role that the judge has been playing during the trial. And I think that we need to go back to that again as well, is that this entire time, like Billy was talking about, the judge during the trial was acting as the person that was making the determinations about what evidence does get reviewed at the end of the trial, right? So normally during a jury trial, and please correct me, attorneys, if I'm wrong, but normally during a jury trial, when you have a jury trial there, the jury is taking notes, and the judge is the gatekeeper on what evidence the jury can review at the end of the at the trial or during the trial, the oral evidence and all that type of thing. And that's where you get objections, and that's what's going on. They're objecting to the entry of evidence and what can be said in front of the jury, because everything that's happening in trial potentially is evidence. And so she's been playing that role, but now, as Billy was talking about, she's got to turn around and also then become the fact finder. She's got to become the jury. And so she's been playing this dual role. And so now she's moving into that secondary role to be the fact finder. Is that a correct? Yeah. Okay. So, and that is a voluminous job for sure.
It's been funny to watch, John, because Judge Silver will make jokes about that, about how she's like the jury, she's the fact finder, and so if she overrules something, she'll say, "And I will tell myself to forget that evidence," you know.
Right.
So,
it is a unique situation because the judge hears it and then makes a determination on it, and then in that case needs to forget it.
But of course, what she means is, in a serious term, she will not use that in her when she deliberates or in her ruling. But she's also kind of making light of it, which it always got a laugh out of everyone.
Yeah, exactly. It's a pretty interesting take, in our system. So let's talk about that. I mean, so we're talking about the amount of time it's going to take to get to a decision. Billy, what's going to happen when that decision lands?
The appeals
Yeah.
will happen.
So let's talk about that process, because I think we're getting really familiar with the appeal process. So, what does that mean, and how does that work?
So we were just talking about why it takes so long, and Julie was talking about how voluminous everything is. Part of whichever decision the judge ends up making, as Julie pointed out, it will be appealed. If the state of Arizona loses, they will appeal. If the other side loses, they will appeal. If both sides win partly and lose partly, and it's kind of a split the baby situation, there will be an appeal. There's going to be an appeal regardless. It doesn't matter what happens. And so the judge knows that. And in the legal profession, we say that a judge's biggest fear is being reversed on appeal. And so judges are, especially in a case this complex, this important, this certain to be appealed, judges want to take their time, and that's part of the reason why it's perhaps taking so long. But what happens with an appeal? I think in one of the previous weeks we had been talking with Jimmy and everyone about how many appeals there have been in this case during the life cycle in the past 7 years, and I forget the number, but it was something more than 7 or 8 separate appeals up to the Ninth Circuit, the regional circuit court. And so, as many of you are seeing in the news on other issues, for example, this week on the issue of abortion, these types of cases get appealed, and then there has to be a decision about whether the lower court's order is stayed, meaning that everything is put on pause, is kind of frozen pending everything else, or whether the lower court's decision is allowed to proceed while the appeals take place. But very likely what will happen is that there will be, for example, if there's a ruling in favor of the plaintiffs saying, yes, there is a deficiency in the medical care system, and I, the judge, am ordering, certain concrete steps be taken, that order is most likely to be stayed for an additional several months. So those of you who are frustrated by how slow it's already taking, you're going to continue to be frustrated, because most likely it will be stayed for up to a year or more while the appeals go through the Ninth Circuit Court of Appeals.
So Billy, even if she orders a receivership, something like that could still be pushed off for a year.
I think that's right. I don't want to speak out of turn because I don't have specific experience with a receivership order being appealed, but generally, as we're seeing with a lot of these politically charged cases around the country on issues like abortion and a lot of the high-profile cases during Trump where things were enjoined. In other words, some bad thing that Trump was doing was halted temporarily, and then there was a stay, and so Trump was allowed to continue doing that bad thing until all the appeals had run. That's typically how, most often the scenario.
Yeah, and even subsequent to, and there's a case that I have in mind where something like this occurred, even after, if say the court was to order that the Department of Corrections healthcare medical care system needs to go to a receiver, and which basically puts it under the court for this period of time, and then the receiver goes about doing their work. The other side can appeal inside that. Is that true? Can the other side make legal challenges to things that the receiver is doing and not doing subsequent to the order that's issued?
Yeah, I mean, we've seen that in other cases where receiverships have been ordered. And yeah, I mean, I think the tricky thing about a receivership generally, actually, a big picture, in order to get a stay, so assuming that, let's presume that, my very biased opinion is in fact correct and the plaintiffs have met their burden. If the judge orders that, what is an extraordinary remedy of receivership? The standard for a stay then becomes a balancing act in federal court. And what it balances is the likelihood of success for the appealing party on the merits and the harm that would come to them if the force and effect of the decision is allowed to go into place. And I think with receivership, it's potentially easier to get a stay than it would be otherwise, for the simple reason that it becomes irreversible harm to the defendants. So if they can even show a slight likelihood of success on the merits and this idea of irreparable harm, if a receivership, takes place while the appeal is pending, I think it's highly likely that it is going to be stayed.
Yeah, absolutely.
But yeah, individual decisions after that can also be appealed.
Right. And as Billy said, and I think, Jimmy, wasn't one or two of the decisions also appealed all the way to the Supreme Court? Did they file writs of certiorari to the Supreme Court on a couple of issues during this?
Well, that's correct. Yeah, none of them were granted, right? But
Right.
yes, I believe that they did do that.
Right.
Yeah, I think the underlying class certification back in 2014,
And
the circuit ruled in favor of the plaintiffs and said, yes, you can in fact bring it. You don't have to bring it on behalf. You don't have to sign up every single one of the 30,000 prisoners individually to bring this lawsuit. You can have 5 or 6 of them representing the class. That was appealed up to the Ninth Circuit. The Ninth Circuit sided obviously with the plaintiffs, with the Parsons group, and then that was appealed to the Supreme Court, but the Supreme Court did not accept it.
And I guess one last distinction on appeal, which is the Court of Appeals, the Ninth Circuit Court of Appeals, who would be the appellate court in this position. They are the ones that are the next step in the process from the United States District Court here in Arizona. That's an appeal of right. Is that an appeal of right as opposed to the Supreme Court being a discretionary appeal? And
Correct.
can we
Correct.
explain what that means to the audience? What an appeal of right as opposed to a discretionary appeal is? So
you have the Ninth Circuit, which is the regional appellate court for the Western states. The losing side has an automatic right of appeal, meaning if they choose to, they don't need to ask permission. They automatically get 3 judges sitting in San Francisco in the appellate court will be forced to be required to review the decision or some aspect of the decision that the losing party chooses to appeal on. The Supreme Court, by contrast, because the volume, the Supreme Court can't possibly take every case that gets appealed up to them, and typically the Supreme Court hears about 100 cases, chooses to accept about 100 cases a year, and there's about 10,000 cases that ask to be reviewed by the Supreme Court, so about a 1% review rate.
Mm-hmm. Yeah. Okay. So that does mean a 3-judge panel to whomever appeals will have to hear this. But then there's other things inside the Court of Appeals, like an en banc hearing and those type of things. And those are discretionary. That's when they ask a 9-judge panel inside the Court of Appeals to review that. And that's a secondary review inside the same court. Is that right? Am I saying that correctly?
Right. En banc is kind of a step between the 3-judge appeal and the Supreme Court. And that is not, it's very rare. It's not automatic, and so there has to be I can't remember the number, but there has to be a minimum number of Ninth Circuit judges that sign off that say, yes, this issue is sufficiently ambiguous or sufficiently impactful that we think it's worth investing, 10 of us judges in kind of a super appellate body to re-review this decision before it gets to the Supreme Court.
Right.
It's kind of an additional bite at the apple.
So it goes back to, it's worth restating that even once this decision comes down, there are so many legal processes and machinations that are still available out there that this is not likely to, but absolutely will be continuing to go on and on for a while, and because everybody has got an interest for their side to litigate these things to their fullest extent, and that means going through all these processes, and so that can be very disconcerting and very upsetting to a lot of people, because they think a lot of people think that once the judge says something or a court says something, then things have to happen. And people obviously here in Arizona that have any type of connection to the Department of Corrections, who have either gone through this healthcare system or have a loved one that's going through this one, or even taxpayers who are having to footing this bill, that can be extraordinarily frustrating, because we want this thing to get resolved and we want this thing to end. And ultimately, it's been one of my arguments, and it's not a unique argument, that the best solution on these things is political, not going through the courts. Is that correct? We all share that opinion? Yeah.
Yeah, big time. I mean, I'll just underscore it. I think the average length of stay right now in an Arizona prison is, was it like 2.5 years for most folks? I think the time for getting resolution on this is going to be about that.
Yeah, that's exactly right. Okay, so let me ask you this, and let me start this with Jimmy. Let me give this one to Jimmy. Jimmy, you've been on this story for so long, and you've heard all of the stories, and you have been in this trial day in and day out. Every day of this trial, you were invested in it. So, what's the one piece of testimony, if there's one piece or pieces of testimony, that really stood out to you as an individual person, as just as a person watching this, but also the second to that is what piece of testimony or testimonies landed with most of your readers and followers on your social media platforms?
Well, I think especially when we published the videos of what happened to Rahim Mohammed, that's gotten the biggest reaction. And for me, been covering this for 4 or 5 years now, but I mean, compared to most folks who are doing the work, still something of a newbie. For me, seeing the treatment of Mr. Mohammed, that really, did something to me, and I think that it had an impact on a lot of other people too. I actually, I've had several people call me and say things like, I've never paid attention to prisons before, but I really didn't think it was this bad. And, one very nice subscriber wrote to me and said, I can't believe this is happening in my country. And I mean, that's just kind of the way I felt too, just seeing some of the abuse. It's just like, I know that correctional officers, I know you know this too, John, they have a very tough job. They're under a lot of stress. But it's just hard to see the brutality that becomes normal for someone. And I think it's interesting that Dr. Craig Haney was one of the people who testified in this trial, who came from the Stanford prison experiment, where we first saw what can happen to literally just bringing random college students in off the streets. They turn into sadists if they're put in the right conditions. And, that was the whole, I think, takeaway from what Dr. Haney told me and what he's talked about in later years, is like, they wanted to see what the atmosphere of a prison could do to someone. And they showed it. It can turn someone into a person who's willing to do really awful things to another human being. And that's what we saw in many of the examples in this case. So I would say, and then to have Mr. Mohammed testify himself after seeing what happened to him, he's actually doing so much better now. He's in a mental health unit where he's getting more interaction with people. And it's hard to believe that it's the same person. And it shows that he by his own words, he said he had to fight for it, but he's on a medication that's helping him now. And he said he's getting more mental health treatment and he's getting more interaction. He's out of his cell more. And of course, all these things happened, I think, near the time when the prisons and the attorneys knew that he was going to be a named plaintiff. And they talked about that a lot in the trial, like, well, you're doing great now, aren't you? But just to see this man be able to live a somewhat normal life now, and to know that he went through 7 years of isolation and brutality and horrible treatment, that for me just kind of summed it all up. It was just really a traumatic thing to see what happened to him. And I mean, I'm just some privileged person just watching these images. I just literally cannot fathom the amount of pain and suffering and agony that we have inflicted on this man. And it's just one case. I mean, that's why I can't. This is and they actually, the prisons tried to hide Rahim Muhammad from the plaintiff attorneys. They were moving him when they were doing tours. I mean, they knew that this was going to be a really awful case study if it ever became public. And through their determination and interviews and everything, they did find him. But the thing that stuck with me is that they said, Mr. Muhammad, what has the past 7 years of being in isolation for so long done to you? And he said, I'm all messed up, and he said, a bullet to the head might have been better than what has happened to me. So just to hear him reflect on knowing what damage has been done to him, I'll never forget that. I'll never forget the young woman who we heard from at the beginning of the trial, who was a healthy, athletic young person, enjoyed basketball, and she's now bedridden with MS. And I think the judge was really taken by her story, the fact that she was delayed care for so long. And I think finally, this acknowledgement here at the very end of the trial that a person in a high-level position at Centurion basically admitted that they need a lot more staff. And that's just been the one thing that I think, I don't know if the case was made maybe to the public, but I think that they definitely did make it to the judge. And it's the thing that I've just been reporting on and hearing over and over and over and over again. The staffing is too low. There are not enough people in the prisons. So, I don't know what the remedy is going to be, but I think that point was hit home pretty hard, and that resonated with me. And it's just, that's just been the culmination of hearing the same thing over and over again for years. So those are the things that stood out to me.
Yeah, those are extremely important. And to that point, and let me ask this of Julie and Billy. Julie and Billy, I mean, Julie, you're a former prosecutor. You both have gone through law school. You both studied the law, both of you. And in that, and I know this from reading innumerable cases myself, you hear and read and see a lot of really disturbing things when you go through the law. Obviously, I mean, that's the law is where we work out these things in our society, right? And so you have some really bad stuff that happens in the world. And certainly with my incarceration for 15 years in the Department of Corrections, I've become pretty calloused to a lot of things. But I can say, for me, that my conscience was absolutely shocked with some of the testimony and evidence that we have seen in this trial. And Billy and Julie, do you share that? I mean, and to what extent has that occurred with you both?
Emphatically, this is. I mean, I started my legal career 8-9 years ago, representing farm workers who had been, basically, literally had crop dusting planes, flying over them, dumping pesticides as they worked the fields, and all kinds of atrocious situations. And I've worked in, asylum where you are regularly confronted with pretty heinous situations of what humans do to one another. And 3-4 years ago, I was, say, privileged to be one of the small number of attorneys through the Parsons lawsuit who, and I won't go into detail, but I was one of the small number of attorneys over the years who was privileged to go into the prison and granted access by court order to do visitations and to interview and speak with individual prisoners. I think I spent a total of five days in that capacity several years ago now, to visit two different locations in Arizona. And this is after I've had spent, been in many different carceral situations, jails, ICE detention facilities, representing farm workers, and nothing has left a bigger imprint on my psyche, as Jimmy alluded to, than those 4 or 5 days I spent in the Arizona prison system. That was 3-4 years ago, and it doesn't seem like much has improved from what I'm reading. And so I would agree that this is probably the worst, the most impactful experience I've had as a lawyer in my legal career. And you tend to become desensitized, as you point out, John. You become desensitized as a lawyer who is confronted day to day with pretty amazing, incredible things that people do to one another. But yes, the Parsons case has left probably the biggest impact on me in my career.
Yeah. Julie, I mean, you came to this without, with really much contact. I mean, you and I've talked about that before. It's not something that was front of mind with you as you were going through life and raising a family and practicing law and doing all these things. How has all of this landed with you as a citizen of Arizona and as a legal professional?
Yeah, it's to steal a quote, it's messed me up too. Listening to these stories has just been absolutely horrendous. Although, if I'm going to point to a moment, I'm not sure it's any of the brave incarcerated folks who stepped forward and testified. What sticks with me the most is just the sheer glibness and smugness of folks who are defending this system. And I'm not sure that there are enough words to encapsulate the tone of, in particular, Shin's testimony and responses to people. It really changed the way I thought about this case, because what it made me realize is that even if there is a win, and even if that win survives multiple appeals, it still only encapsulates healthcare, right? It doesn't encapsulate the brutality that we're hearing. And that's a culture problem that pre-existed Shin, but that's something where he has not taken the accountability and hasn't taken the actions. It's just listening to him and his attitude. It just seems so hopeless. To underscore, I haven't been in an Arizona prison, but listening to the folks from the prison law office they shared Billy's take on this, that this is not just bad, this is the worst that they have ever seen. And going into bad prisons that mistreat folks is what they do all day, every day, and have done for their entire careers. So I think that's shocking. I think it also leads to another, the point that prosecutors have to get into prisons to see what they are recommending. They just have to. And I know that that's been part of a national push, that when you are sentencing folks and when you are making these recommendations to years or decades behind bars, that what you're really sentencing someone to in Arizona is, I sentence you to a decade without healthcare. I sentence you to a decade of being brutalized without accountability. And I think that's the part that stuck with me, that this trial, is as groundbreaking as it was, is still not the answer to all of these problems that are in our Department of Corrections.
It truly is, and extraordinarily well said by all of you. The impact of not only the story, but you're absolutely right, Julie. I mean, this is just one issue, and that's something that here at ATAC that we talk about and we work on constantly, right? Because we're looking at these things system-wide, systemically. We're looking at all of the issues at ATAC, healthcare being obviously a huge and large part of it. But these things, these mismanagement, chicanery that goes on, the absolute tone deafness, the bias, the prejudice, the brutality, like Julie was enumerating there, all of these things, they're manifest in every area of life inside the Department of Corrections. And so we're seeing that across the board. And this tees me up for something that I really want to take a moment for is it's with Jimmy and Jimmy's reporting. And if not, but for, I started my time in the Department of Corrections in 2003. And for years and years and years, we sat in there just hoping and praying and begging that somebody would listen to the things that we were saying. And it largely fell on deaf ears in the public realm. And there has been, I don't think any greater reporter that has worked on this beat than Jimmy Jenkins has. And your steadfast, dogged approach to the Department of Corrections, especially in the face of the clamping down on transparency that's occurred with Director Shin, is just unparalleled. And it means the world, I know, to everybody that's incarcerated, for these stories to just get out of the fences and get to the light of day, and to be evaluated, to just get out there, because the Department of Corrections does control the narrative that comes out of the Department of Corrections. It's one of the most isolated agencies that we have in the state, and they literally operate behind locked fences, and they lock the public out, and they lock the incarcerated in, and then they use a number of systems to control that information that comes out. And so Jimmy, to have somebody like yourself that has dedicated so much of your professional time and energy to this story, and to what's going on in our prisons, it's just, if I could give you any awards, I would give them all to you, because it's just absolutely second to none, man. And
all right.
well, it really is. And it speaks to me about the need to get this information out, and there needs to be a mechanism to get the truth out of those fences. Because once we do, like Billy said, once you walk in and you see, and Billy spent 3-4 days in there talking to people, and when you do, and you do get in there, and you start seeing the truth, and you start seeing that our government agents have been misleading us as the public and the press and everybody else in the state as to what is going on in the internal operations of the Department of Corrections with our money, with a $1.3 billion per annum of our cash that we're paying for, we see that we cannot continue this. And that's what underpins our work. And and our work here at ATAC is made exponentially easier by your reporting, Jimmy, because you do such an incredible job on this. And so thank you for that, man. You really, really, it's a huge thing that you've done here. Just being the objective reporter that you are on this issue. So thank you.
Well, that's really kind of you. There's been a lot of reporters that have reported on the prisons over the years, but I think I've been fortunate to have editors who've allowed me to focus most of my time on it. So, I think that's the difference, and I do care about it. And I think I have shown that other press you can trust incarcerated people, you can trust their families, so I hope that's what comes out of this, is that we can all start thinking differently about, questioning the press releases that come out from the Department of Corrections, just like reporters are learning to question the press releases that come from the police. It's all kind of part of the same sort of police state in many ways. So I've just been trying to go about it in a skeptical way, and with the people in power. And I've tried to give more credit and trust to the people who don't have power. And that has served my reporting really well. And, I wouldn't be able to do any of this without people with a lived experience like you, John. So, thank you for all that you've taught me, and for all the assistance and guidance you've given me in my reporting. I've come a long way. I remember 7 or 8 years ago, when I first met ACLU attorneys at the courthouse, I was like, should I be writing like what these people were charged with? Like, is that something that I should include in my reporting, or is that problematic? And, I've come to learn things like it doesn't matter, because everyone's guaranteed constitutional healthcare, so I think it just takes the press a long time to get hip on a lot of topics, and it's taken me a long time. But I think the reaction from the public has been really positive, in my opinion. I don't get a lot of trolls. I don't get a lot of people saying, "Oh, you're just looking out for these murderers and whatnot." Quite the contrary. From the public radio audience and from the print audience now, I get a lot of people who say, "Wow, I didn't know it was like this. I didn't know it was this bad." So, I think it's just, if anyone is able to take the time and to report on it, I think, the audiences have responded well to it. And, but like you said, it is really tough. So, I mean, there's been a lot of people who have tried for many years to tell so many different stories, and even a fantastic reporter just can't get it done sometimes because of all the obfuscation. And, we've seen the extent that the prison system is willing to go to cover things up and to be dishonest about it. And their contractor does the same thing. They've been busted on it, by me and other reporters, and in the courts and in their own words. So it's just a very powerful, closed off system, and it just takes a lot of time to break that down. And I just feel fortunate to be able to have worked with people, formerly incarcerated people and their families. I'm just very grateful for the trust that they put in me, because I couldn't do any of this without them.
Yeah, and it truly is. You hit a couple points there. Go ahead, Billy.
I was going to say, give a gift this holiday season to a gift of membership to KJZZ in Phoenix.
And by your subscription to the Republic, yeah. And you're absolutely right, Jimmy. There's no doubt about it that that without KJZZ, your prior employer, and now the Arizona Republic supporting you, and giving that opportunity, and that's incredible too. So we want to laud them as well and say thank you to them and your editors as well for allowing you to operate in this space, with the ability that you have brought to this and the professionalism that you brought to this, and getting those stories out. And that is, here we are, Arizona. We are sitting here at the end of a massive class action trial behind healthcare, mental health care, and solitary confinement uses in our prison, which are just three of 100 different areas in the Department of Corrections that need immediate attention. We've got issues relative to staffing, critical issues relative to staffing, to security, to infrastructure, to potable water at our facilities, to food, insects. Jimmy, again, just go through Jimmy's reporting, and insects and food and unsanitary conditions, and fuel leaking into drinking water in Douglas Prison, and being out of water for 1, 2, 3, 4, 5, 6 days at Iman or Florence or Perryville most recently. And we're talking about 5, 6, 7,000 people without having water. And we're paying $1.3 billion for that. I was talking to Julie last night, and I was talking about an analysis that we had done here at ATAC that showed from 2017 to 2021, just that 4-year period, there was a 19% increase in the budget in the Arizona Department of Corrections, $60 million additionally every single year for the last 4 years, 4 years up to this last one, and they did increase the budget again this year. That's our money. That's money that's not going to teach children how to do math. That's not going to repairing our roads. That's not going to providing health care or elder care or any myriad of issues. And the problem is that when you get into the documents of the Department of Correction and you start looking at the truth of what's going on, none of those issues are being addressed. So the money that we're spending into the Department of Corrections isn't ever even touching any of these sub-issues that are making the Department of Corrections operate to where it's a complete, it's nearing a complete systemic failure. And that's manifest in what we're seeing here in healthcare. It's manifest in what we've seen with escapes and safety issues for the incarcerated and for staff, and any myriad of issues. I mean, we could go on and on about that, and that's the work that we do here at ATAC, is to bring that understanding out, and that's made much easier by the incredible work that Jimmy does and some of the other reporters in town that have brought out some of these really important stories. we are extraordinarily happy that this is now an area of focus for press, and Jimmy has been on the vanguard of leading the press into this area for a lot, but we are starting to see more and more press look at this issue and ask these really important questions, like where is the money going? What are we doing inside of our Department of Corrections? What are the results that we're getting? And these are the things that we need to be paying attention to, Arizona, because this is our money. This is our Department of Corrections. This isn't their Department of Corrections. We own it. These things, these acts and omissions that we've talked about in this trial and in these panels are being committed in our name, with our money. And so and this is what I mean by we need to have a political solution to this, because all we're going to keep doing here is just keep going through these cycles of bad conduct and then court action, and bad conduct and court action. And until we take a much broader and holistic, comprehensive view of what's going on in the Department of Corrections and correct this on the political level and pass a strong legislation that puts in independent external oversight and transparency mandates inside the Department of Corrections, we're going to continue to live this over and over again, and we're going to squander our tax dollars that should be going to education, healthcare, infrastructure, and so many other issues. So this is an extraordinarily important issue. When the decision comes down, wherever that be, if that's going to be in late February or March, I would be really privileged if we could assemble this panel again to go through that decision and talk about the impact of what we see in the court's determination based on this case. So we will anticipate that, and we will talk about those legal machinations again at that point. But we'll put this panel together, willing with the participants to analyze that when that does happen. In the short term, I want to make sure that everybody knows that upcoming this very next Tuesday at 6 o'clock here on Facebook Live, we will be hosting a panel that will be moderated by Julie Gunnigle, that will be bringing in Representatives Walt Blackman and former Representative Diego Rodriguez, who's now a candidate for Attorney General here in the state of Arizona. And they're going to come in and talk about the legislative process and this political process that I've been talking about here so far, and the realities of legislative solutions moving forward relative to the Department of Corrections. We've got oversight legislation that will be proposed again this year, and I do know that Representative Blackman and Representative Rodriguez did file a joint bill to stop privatized healthcare provision in the Department of Corrections. And so we need every citizen in Arizona should be engaged on this issue. And should be aware of what's going on here and should be aware of this upcoming legislation. The next legislative cycle begins on January 10th. That's the second Monday in January. And most of these bills will come up through the House Judiciary Committee. Feel free to reach out to us at ATAC if you have any questions. Our website is aztraco.com. You can find us there. You can find us on Facebook and Twitter. And we do have a YouTube channel where you can see these videos and others that we have done previously with panels and on other issues. We have the We're Just One Family series that's up there that our incredible mixed media content provider Haley Worrell has created, talking about these issues from the family perspective and what it means to have somebody that's incarcerated in the Department of Corrections and a loved one that's in there or formerly incarcerated as well. And we will continue to have these legal panels as situations come up, and these political panels like we have next Tuesday. So stay tuned with us, and we'll keep you informed on exactly what's going on here at ATAC. Jimmy, Julie, Billy, thank you so much for everything that you've given us here at ATAC, for joining us on all of these panels and explaining all of this really complex and difficult things to understand, and the impact of what it can mean, and all of the day in, day out stuff that you've done too, Jimmy, on bringing all this to us. We couldn't have done all of this without all of you. And to Stacy Scheff, thank you very much, Stacy Scheff, for the panels that you joined us on as well. Your insights were incredible. Thank you all very much for joining us tonight. And we will see you this Tuesday, 6 o'clock here on Facebook Live as we talk with Representatives Blackman and Rodriguez about legislation coming up this year. Thank you so much, and you all have a wonderful evening.